5 seconds to go. Start. The plaintiff, deposing as PW1, specifically stated that he, along with his staff, met with the defendant number 1 personally in the house of her father at Beltali, Agartala on 21st August 2016 and told her as to whether she could obtain the said survivor certificate and the guardianship certificate. From such evidence of the plaintiff, there cannot be any doubt that the defendants had no shelter other than the father of the defendant number 1, and according to us, this admitted fact is enough to prove the hardship of the defendants that the defendant number 1, who along with her minor son would be rendered homeless and shelterless if the suit for specific performance of the agreement of sale exhibit 1 is decreed in favor of the plaintiff. Applying the well settled principle that it is not always necessary to grant specific performance simply for the reason that it is legal to do so, we are of the opinion that the case in hand is a fit case to exercise our discretion, rejecting the plaintiff's claim to ask the defendants to execute the deed of sale in terms of Exhibit 1 as decreed by learned court below. As a sequel, we hold that the plaintiff is not entitled to get a decree for specific performance of the agreement of sale Exhibit 1, and the defendants are not under any obligation to execute the sale deed in favor of the plaintiff in the light of the agreement of sale Exhibit 1. However, the plaintiff is definitely entitled to get refund of the earnest money which he paid to late Prabha Ranjan Das, the predecessor of the defendants, along with interest at the rate of 8% per annum. The defendants shall refund the said earnest money of Rs 4 lakhs along with simple interest at the rate of 8% per annum to the plaintiff from the date of the institution of the suit within a period of 3 months from today. The appellant herein being dissatisfied with the impugned judgment and order passed by the High Court is here before this court with the present appeal. Section 20 of the Specific Relief Act 1963 as it then stood, that is, prior to the 2018 amendment, reads as under. The jurisdiction to decree specific performance is discretionary and the court is not bound to grant such relief merely because it is lawful to do so, but the discretion of the court is not arbitrary but sound and reasonable, guided by judicial principles and capable of correction by a court of appeal. The following are cases in which the court may properly exercise discretion not to decree specific performance: where the terms of the contract or the conduct of the parties at the time of entering into the contract or the other circumstances under which the contract was entered into are such that the contract, though not voidable, gives the plaintiff an unfair advantage over the defendant, or where the performance of the contract would involve some hardship on the defendant which he did not foresee, whereas its non-performance would involve no such hardship on the plaintiff, or where the defendant entered into the contract under circumstances which, though not rendering the contract voidable, makes it inequitable to enforce specific performance. Mere inadequacy of consideration or the mere fact that the contract is onerous to the defendant or improvident in its nature shall not be deemed to constitute an unfair advantage within the meaning of clause A or hardship within the meaning of clause B. The question whether the performance of a contract would involve hardship on the defendant within the meaning of clause B shall, except in cases where the hardship has resulted from any act of the plaintiff subsequent to the contract, be determined with reference to the circumstances existing at the time of the contract. The court may properly exercise discretion to decree specific performance in any case where the plaintiff has done substantial acts or suffered losses in consequences of a contract capable of specific performance. The court shall not refuse to any party specific performance of a contract merely on the ground that the contract is not enforceable at the instance of the other party. The relief of specific performance having its roots in equity, the Specific Relief Act 1963, prior to its amendment, has preserved the discretion of the court not to grant the relief even though the agreement is specifically performable in law. The only fetters imposed by the statute on the exercise of the discretion are that the discretion must not be exercised arbitrarily but soundly and reasonably and guided by judicial principles. The phrase capable of correction by a court of appeals has been inserted possibly to indicate the necessity for the trial court to state the reasons for exercising its discretion in a particular way. The circumstances when specific performance mentioned in the clauses A, B, and C of subsection 2 of section 20 cannot be granted are not expressly exhaustive. They indicate the situations in which the court may properly exercise discretion not to decree specific performance. However, certain considerations have been excluded as relevant factors. These are contained in explanations 1 and 2 to the section as well as in section 24. It is to be noticed that each of these exclusions are preceded by the word mere. The word mere in the context means sole. In other words, any one of those factors by itself would not justify the exercise of discretion against granting specific performance. The factors cumulatively or with other factors may form the basis of a decision not to grant specific performance. Hardship of the defendant may be one of the grounds which may be taken into consideration for exercising its discretion by the court in refusing to grant a decree for specific performance of contract. In K. Narendra versus Riviera Apartments Private Limited, reported in 1999 5 SCC 77, this court held as under Section 20 of the Specific Relief Act 1963 provides that the jurisdiction to decree specific performance is discretionary and the court is not bound to grant such relief merely because it is lawful to do so. The discretion of the court is not arbitrary but sound and reasonable, guided by judicial principles and capable of correction by a court of appeal. Performance of the contract involving some hardship on the defendant which he did not foresee, while non-performance involving no such hardship on the plaintiff is one of the circumstances in which the court may properly exercise discretion not to decree specific performance. The doctrine of comparative hardship has been thus statutorily recognized in India. However, mere inadequacy of consideration or the mere fact that the contract is onerous to the defendant or improvident in its nature shall not constitute an unfair advantage to the plaintiff over the defendant or unforeseeable hardship on the defendant. The principle underlying Section 20 has been summed up by this court in David and others versus Chinaya and others 1996 5 SCC 589 by stating that the decree for specific performance is in the discretion of the court, but the discretion should not be used arbitrarily. The discretion should be exercised on sound principles of law capable of correction by an appellate court. Stop.